welcome to our webinar for carers on mental capacity, the Mental Capacity Act and deprivation of liberty. This is a short webinar for informal carers that is based upon the CQF MVQ course that we run for our paid care staff. Because we've altered the format to make it more appropriate to you as an informal carer, there are a number of things that we've left out, but we hope that you will find the webinar informative and useful. So, let's look at the aims of today's webinar. We'll certainly be giving you an overview of the Mental Capacity Act. We also hope to give you more confidence by increasing your knowledge in this area. In all of our webinars, we like to have some learning outcomes. So by the end of this short session, we hope that you'll be able to understand the aims of the Mental Capacity Act, shortened often to MCA, understand the 5 principles of the Mental Capacity Act, understand who might be affected by the Act, understand how and when mental capacity can be assessed, understand how to work out what's in a person's best interests, and have some understanding of deprivation of liberty, although we will not be looking at this in any depth. What is the Mental Capacity Act? The first thing to understand is that it is a law and something that needs to be abided by. It applies to people aged 16 and over, and in essence it explains how to balance 2 things: the empowerment of people to make their own decisions wherever possible, with the protection of people who lack capacity by placing them at the heart of decision making about them. It also enables people aged 18 or over to plan ahead for a possible loss of capacity in the future. There is a code of practice around the Act. This is mainly for people who are paid to work in the area, but if you employ care staff at home or have a deeper interest, it may be a good idea to have a read of this code of practice. So what do we mean by mental capacity? Mental capacity can be defined easily in one sentence. Can this person make this decision at the time it needs to be made? It does not mean, is this person very old? Do they have a condition that affects their memory? Or are they a bit different in their lifestyle? It does mean a person may lack capacity for a particular decision, but may be able to make other easier decisions. It does mean a person may lack capacity at one time, but regain it at a later date. The Mental Capacity Act acknowledges that capacity might fluctuate, and that because a person might lack capacity to make a decision about one particular part of their life, this does not necessarily mean that they lack capacity to make all decisions. Therefore, the Act applies to situations where a person may be unable to make a particular decision at a particular time, and that assessments of capacity must be time and decision specific. Let's have a look at some of the key principles of the Mental Capacity Act. They provide a clear outline of how we should look at mental capacity. Firstly, a person must be assumed to have capacity. Secondly, a person is not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken. Thirdly, a person making an unwise decision is not to be assumed to be lacking of capacity. You might not agree with a decision, but if the person is competent, then it is their decision to make. Fourthly, an act done or decision made must be done or made in a person's best interests, and this is something we'll look at again later. Lastly, can the purpose be achieved in a way that is less restrictive of the person's rights and freedom of action? We do not want to introduce any restrictions unless it is absolutely essential. Let's look at when we should assess someone's capacity. Remember again that these slides are aimed at paid staff, but do have relevance to you as an informal carer. Firstly, the person is facing a decision or series of decisions and is either refusing to make them, or decisions they are making are out of character. Secondly, all has been done to enable the person to make a decision, but there is still doubt about their capacity to do this. Thirdly, if the person does lack capacity for this decision, it will have to be made in their best interests. And fourthly, the care plan is based on an assessment that the person lacks capacity, but it is possible that the person now has regained that capacity. Is it that the person has regained capacity? So, how is someone's capacity assessed? This is a task undertaken by a professional, but is useful and important to understand how it's done. The Mental Capacity Act has a two-stage test for capacity. In step 1, to lack capacity, a person, even with all possible help, must be unable to do at least one of the following. Firstly, understand information about the decision suitably presented. Secondly, retain the facts, but not every fact or for very long, but the important facts for long enough to use or weigh the information to reach a decision. And thirdly, to communicate that decision, for example, using words, sign language, or pictures. In step 2 of the assessment, there needs to be a decision around whether there is some impairment of or disturbance in the functioning of the person's mind or brain, and, if so, is the reason why the person cannot do at least one of the 4 previous points probably because of this impairment or disturbance. As I promised, now we're going to look at some of the issues around what is defined as a person's best interests. It's important to look at how we establish a person's best interests, but luckily the Mental Capacity Act sets out a statutory checklist for us to work with. Firstly, make sure you or care staff are not making assumptions or stereotyping the person. Secondly, will the person regain capacity? And, if so, can this decision wait? Thirdly, what are their wishes and feelings now? What were they when they had capacity? Fourthly, what religious, cultural or personal beliefs would be important to this person? And finally, it's important to consult relatives or friends who may know more about the person's wishes and feelings. If we look at this list, I think that it's obvious that these are things that we would want taken into account if this decision was being taken about us. Thinking about it in this way always helps. Just a little bit about record keeping. As an informal carer, it's worth noting the types of records that can and should be kept around mental capacity. If you have carers, then there should be a care plan, and there will also be a number of formal reports and assessments if the person you are caring for has been assessed for their capacity. What about planning ahead for a loss of capacity? If you're aged 18 or over, then it is possible for you to plan ahead for a potential loss of capacity. It can be really important to know how someone can make decisions that will apply if they lose their capacity. An advanced decision to refuse treatment, for instance, has the same power as if a person with capacity is refusing treatment. It is made when the person has full capacity, but only applies if the person loses capacity, refers to medical treatment only, including clinically assisted nutrition and hydration, and can be used to refuse life-sustaining treatment, but special conditions do apply. It is worth thinking ahead about capacity, and this is where a lasting power of attorney can come in very useful. Lasting powers of attorneys can be for finances and property and or health and welfare. They give the power to make decisions to someone trusted, often a relative. They can apply to a wide range of health and welfare decisions, be personalised, so care plans need to be clear regarding what decisions the LPA attorney can make. Give the attorney power to agree or not to life-sustaining treatment for the person, but the attorney must decide in the person's best interests. Now, I'd like to turn briefly to the issue of safeguarding. Any adult lacking capacity can be considered an adult at risk, and because of this, organisations with responsibility such as the local authority will have policies and procedures that they need to follow. If you want to know more about this, it is worth speaking to your care worker, if you have one, or the local authority themselves. I'm now going to look very quickly at the issue of restraint. This is not something that we will look at in any detail, and it is important that you speak to a professional to get the right advice in this area if you think that the use of restraint may be necessary. The Mental Capacity Act defines restraint as, firstly, the use or threat of use of force to make someone do something they are resisting, and secondly, the restriction of the person's freedom of movement, whether or not they resist. Restraint is only lawful if it is in the person's best interests and also is necessary to prevent harm to that person and is a proportionate response to the likelihood of this harm to the person and how serious it would be. Now to look at consent and what we mean by consent. In essence, consent is given permission for something to happen or agreement to do something. To give meaningful consent, a person must be able to understand what they are giving permission for or agreeing to do. There may be occasions when, due to their condition, an individual is unable to make a considered decision and support is needed to help them give consent, or consent may need to be given on their behalf. If there are no times, it may be possible to support the individual to make their own decision with the time that it takes, having none or little impact on the outcome. If the decision is time sensitive, such as a life-saving operation, there may not be enough time to wait to see if the individual is able to make the decision for themselves, and others may have to make that decision for them. We're now going to take a brief look at the issue of deprivation of liberty. This is a brief look at a serious subject, but we think that it might be helpful for you, as an informal carer, to have some knowledge of the rules surrounding the issue. Much of the following information applies to paid staff and organisations like care homes, so please bear that in mind. There are a range of safeguards that are in place in this area. The Human Rights Convention states that every person has the right to liberty. Liberty means being free to do the things you want to do and live where you want to live. Deprivation of liberty means to take someone's freedom away. Deprivation of liberty safeguards is when there is a need to restrict a person's freedom for a particular aspect of their life for their own safety. The deprivation of liberty safeguards are an important way of protecting the rights of people at risk who are or may become deprived of their liberty within the meaning of Article 5 of the European Convention on Human Rights in a hospital or care home setting. So, what are the safeguards and how do they work? They protect the rights of people who are aged 18 or over and who are in a care home or hospital in England or Wales, and this includes nursing homes, and whose care plans meet the acid test for deprivation of liberty, and where there is no less restrictive way that can be found to give them the care and treatment that they need. So what is the acid test for deprivation of liberty? A person lacking capacity to consent to the arrangements for giving them essential care or treatment is deprived of their liberty if they are, first, under complete and effective supervision and control of staff, and second, are not free to leave. Someone may be taken out by staff or relatives, or even alone provided staff give permission, but would not be allowed to go and live somewhere else of their own choosing. Deprivation of liberty must be authorised to be lawful and for staff to be protected from liability when depriving someone of their liberty. The safeguards protect people in the following ways. They provide a way that the person can challenge this deprivation of liberty to the local authority or, if they wish, the Court of Protection. They make sure the person has a representative and, if needed, an advocate to help them challenge. They provide external scrutiny of the care plan. Assessors will look at the person's care to check, for example, that the person really does lack capacity to decide to be in this setting. The care plan and restraints within it really are in their best interests. In particular, that the restraints are both necessary and proportionate. And finally, that there are no less restrictive options to meet the person's needs. As I said before, these standards are for use in hospitals and care homes, but what about care in your own home? The deprivation of liberty safeguards cannot be used if the person who lacks capacity is aged 16 or 17 or lives in a setting other than a hospital or care home. In this instance, the Commissioner applies to the Court of Protection for authorisation, which gives the same protection to those who are aged 16 or 17, or receiving domiciliary care in their own home, or living in a supported living setting. So as we come to the end of this webinar on the Mental Capacity Act, I think that it's important to remember just a few things. The Mental Capacity Act is the practical way to balance empowerment wherever possible with protection where unavoidable. It's intuitive because it's based on existing best practice, and essentially it is the way we would all want to be cared for and supported. We do hope that you found this webinar useful. Barnet Carers are an accredited training provider of Advantage Training. This brief webinar is based on the training that we provide to our paid care staff. However, it is important to say that the webinar is for information purposes only. If you would like more information on the Mental Capacity Act or deprivation of liberty safeguards, you should contact your local authority or speak to your professional carers or social worker where you have one. Thank you very much for attending.